Montanans Securing Reproductive Rights says they collected more than 117,000 signatures to get Constitutional Initiative 128 onto the ballot in November. On Tuesday, they put out a statement saying that valid signatures were being rejected because of new guidance from the Montana Secretary of State's office. The group said they filed public records requests and received emails between the Secretary of State's office and local election administrators, in which state officials said they should not count petition signatures from voters who are registered but on the inactive list. Inactive voters either haven't voted in a recent general election or had a mail ballot returned as undeliverable. They don't receive mail ballots, but they can reactivate their registration by going to the polls to vote or filling out a form. Montana law says you have to be a qualified elector to sign a petition. MSRR said the state constitution says anyone who meets registration and residency requirements is a qualified elector, and that should include people on the inactive list. They said they'd file suit if the Secretary's office didn't change course. In a response to MTN, the Secretary of State's office said this wasn't new guidance. They pointed to a section of Montana law that says an inactive voter becomes a qualified elector by going through the reactivation process, so they argued those voters aren't qualified. They also cited an Oregon Supreme Court ruling that said inactive voters aren't eligible to sign initiative petitions. Any legal action on this issue could affect not only CI 128's qualification, but also two other proposed measures, CI 126 and 127, which would overhaul the state's election system. County election officials are supposed to forward petitions and certified signatures to the Secretary of State's office by July 19th. The Secretary of State will then make the determination of which proposed measures qualified for the ballot. In Helena, Jonathan Amberian, MTN News.